Hello, and welcome to another episode of Trust and Trade, a podcast produced by the Antitrust Law section of the American Bar Association. Trust and Trade is a podcast for seasoned practitioners interested in deep dives into the areas of competition, consumer protection, and privacy law, and casual listeners curious about the controversies at the forefront of these fields. Each episode is presented by one of the specialty committees within the section. This episode is produced and co-hosted by the Distribution and Franchising Committee. Today's episode is on the hidden impact of the Shipping Act antitrust exemption. If you're listening to this podcast in your home or office, take a look around. Most of what you see in front of you spent some time in an ocean shipping container. By some estimates, 80% of consumer goods travel via ocean shipping. The size of these networks and their economies of scale are vast. It's what enables us to eat bananas for breakfast, freshly harvested in South America a few weeks ago, costing us only a few cents per pound. Like the airlines, ocean shippers have aligned themselves into just a handful of major networks. This squeezes even more pennies out of economies of scale, but it also eliminates a lot of cushion and redundancy in the system, leaving shipping, and by extension, most of what you see around the room you're in, subject to stressors that can change the cost structure. This was felt acutely during the pandemic, when ocean shipping rates increased 2 to 10 times their pre-pandemic levels, triggering inflationary impact across the globe, while also delivering record profits to the shipping lines. The Federal Reserve Bank of New York estimates that 40% of inflation between 2019 and 2021 was caused by supply shocks. Like the airline and railroad industries in the U.S., shipping started with robust regulation and then underwent steady deregulation. Ocean shippers have also long enjoyed an antitrust exemption, one of the oldest in U.S. law, under the Shipping Act, which regulates ocean carriers' operations and the transport of goods they carry to and from the U.S. Today's episode is on the hidden impact of the Shipping Act exemption. For something that is such a central part of our daily lives, why is there an antitrust exemption? And do we still need it? Joining me today as my co-host is David Golden, a vice chair of the Distribution and Franchising Committee. David is a partner at Constantine Cannon and specializes in antitrust litigation. David, thanks for being on the show today.
Thanks, Anant. In the wake of the COVID pandemic and ongoing supply chain issues, public attention has been focused on the ocean shipping industry. The Shipping Act and its antitrust exemption may not be familiar to many in the antitrust practitioner bar, so we're going to discuss it today.
Great. Who do we have on the show today?
First off, we have Melissa Maxman. She is the managing partner of Cohen and Gresser's Washington, D.C. office. She also leads the firm's antitrust and consumer protection practice. Melissa has been recognized in the Legal 500's U.S. Guide, Chambers USA, and DC's Super Lawyers each year since 2011. She has been also recognized by Law Dragon as one of 2022's 500 leading litigators in America. And we also have Kathleen Bradish. She is the acting president of the American Antitrust Institute, one of the premier antitrust think tanks in the country. She is also the co-author of a recent AAI white paper on the Shipping Act called Competition Enforcement, Private Actions, and the Shipping Act.
Well, let's get right into it. For the listeners out there who aren't maritime lawyers, David, what is the Shipping Act and what does it do?
So as you noted before, Anant, the Shipping Act has been around for quite some time. And the Shipping Act applies to ocean transportation, or the Great Lakes, between any point in the U.S. and a foreign country. Ocean transportation that continues inland into the United States is also covered, depending on the circumstances of that transportation. The Shipping Act is enforced by the Federal Maritime Commission, and throughout the podcast today, we will refer to the Federal Maritime Commission as the FMC. Notably, the Shipping Act contains an antitrust exemption. The antitrust exemption applies to agreements that must be filed with the FMC or for conduct that is explicitly exempted under the Shipping Act. Examples are for rate or capacity agreements or vessel sharing agreements. Other ocean shipping agreements and conduct falling outside the exemption can be challenged under the Sherman and the Clayton Acts, such as mergers and acquisitions, agreements among marine terminals, and conduct related to transportation within the United States that is not already regulated by the FMC.
So what role does the Federal Maritime Commission play as a forum for competition disputes?
Well, if the antitrust exemption applies, injured parties have two options. They can petition the FMC directly to investigate or potentially open a rulemaking, or they can bring a private action at the FMC. So to bring a private action at the FMC, there must be a nexus to the shipping public for jurisdiction to lie. Mere contract disputes or labor agreements are not covered. FMC rules of practice generally follow the federal rules of civil procedure, although there are some differences here and there. Injunctive relief and damages at the FMC, those are called reparations, are available, and reparations can be doubled and attorney's fees can be awarded.
So then let's just get right into the heart of this, the question that we posed at the top. Does the policy behind the Shipping Act antitrust exemption still make sense? Kathleen, let's start with you. What are some of the problems you see with having this exemption?
Sure. And thanks for having me. I think what we saw highlighted very strongly by the pandemic was that the supply chain distribution disruptions that we saw during the pandemic really showed the downside to the antitrust exemption. We saw higher prices, we saw service disruptions, and all of these are qualities of concentrated industries. And this is the perfect example of a concentrated industry. We have high market shares, relatively speaking. That concentration has been growing. We have the top 20 ocean carriers have about 90% of the world's slot capacity. But that doesn't reflect the true levels of concentration here. It's dramatically more concentrated than that. And the largest steamship lines, none of which are US based, are organized into three major global alliances. 2M, which is Maersk and MSC, the Ocean Alliance, and the THE Alliance. And those three major alliances constituted 91% of the market share of trans-Pacific trade and 89% of transatlantic trade.
So one issue, as you just pointed out, is concentration. A second issue that jumped out at me during our planning call is how the Federal Maritime Commission is almost like this uncontacted tribe in terms of its isolation from the development of antitrust common law. Can you tell us a little bit more about that?
Yes, of course. And I thought that was a great that was a great analogy, because what we have here are basically an alternative antitrust regime. But this alternative antitrust regime does not work like our typical antitrust regime, and in particular is not nearly as transparent. We don't get a lot of insight into what's going on at the FMC in the way that we do when DOJ or FTC brings a court case. And we know that the standards are different between the FMC and the federal courts. So there are a couple of really important reasons why it's harder to bring private cases in front of the Federal Maritime Commission. The standards aren't as clear, and there is a significant difference in how the damage schemes work. There are double versus treble damages, double damages with the FMC versus treble damages in a typical antitrust case in federal court. And it's frankly, it's harder to show damages. It's a higher bar in front of the FMC. And really that leads to the potential, a very significant potential for under enforcement and under deterrence.
And so this under deterrence and under enforcement leads me to, I think, the next criticism of the structure of the FMC, which is that it can create an enforcement gap, according to the critics, where the FMC doesn't act. And that's why I'm so glad that Melissa's on this program, and I want to bring her in. And I want to talk about a recent case in the last few years, the roll-on, roll-off litigation that Melissa was involved in. This is an example of where you might have kind of overlapping Sherman Act and Shipping Act competition enforcement. But Melissa, can you tell us a little bit about this case and what exactly happened in this case?
Sure, and thanks for having me, Anant. This was called In Re Vehicle Carrier Services Antitrust Litigation. And what happened was in 2012, a number of different countries did dawn raids because they had information leading them to believe that, in fact, shippers of roll-on, roll-off vehicles or carriers of the roll-on, roll-off vehicles. The shippers are the people who are actually shipping. The carriers were fixing prices. And, excuse me, after these dawn raids were carried out, there were indictments brought and there were guilty pleas. And it was against 6 of the major roll-on, roll-off, or RO-RO, as we call them, carriers. Now, roll-on, roll-off applies to a very specific type of shipping. In fact, these are vehicle shippers. So they ship everything from cars to trucks to military equipment, tanks, equipment like anything with wheels, anything that can roll on and roll off. And the thing about RO-RO, or these carriers, is the ships are configured differently. It's not like shipping pears or bananas or widgets of some sort. These literally are huge pieces of equipment. Each one is very expensive, and very few of them, relative to bananas, can fit on a carrier. And the carriers they literally roll the machines, the vehicles, onto the boat, onto the ship, and they roll them off. And obviously they have to secure them properly, and they've got to configure it properly because they're also, quite frankly, very fragile. And a lot of the litigation that I've experienced anyway has been when there's damage to a vehicle that's been shipped, because it can be very expensive. Now, the roll-on, roll-off industry is exactly why an exemption is needed in my mind. And I understand the arguments of, the exemption applies to everyone and that it may not be as necessary in other industries. But in the roll-on, roll-off case, the shippers have to, the carriers rather, have to ship a certain amount of vehicles. The more vehicles you get onto a ship, the more lucrative it is. But you do not want to travel with anything empty on your ship, because that's lost money. These ships take months to cross the ocean. So if something's coming from Japan or Korea to North America, it literally takes months. You want to have the proper weight, because the proper weight enables you to go faster or slower, depending on what you want to have happen. And oftentimes, if a shipper does not have a full load, one way or the other, they don't want to go empty either way, they will contract with another shipper, another carrier rather, to lease some space. So you are never shipping with an unfilled ship. And what the carriers were worried about was the fact that they've got these vertical and horizontal relationships, as we call them in antitrust, because on the one hand, they're all competing against one another, and on the other hand, they are almost always leasing some of their space to another carrier. They didn't want that to be seen as an antitrust violation. So this interaction, this vertical interaction, and as well as the horizontal interaction, created the need for an exemption.
And Melissa, can I want to pause right there and have Kathleen come in and respond to this, because I think this is a really interesting argument you make. But I'm going to play skeptic here. I mean, why can't you achieve all of those benefits short of an exemption? You see the DOJ offering guidance on joint ventures without providing an actual exemption for joint venture, but giving companies some guidelines for how they can work together. Kathleen and Melissa, is the exemption truly needed in this kind of example?
Well, from my perspective, I think the need for an exemption should definitely be questioned at this point. This is an old exemption, clearly, as we discussed at the top. And I think it is best practice to look at exemptions, examine them over time, make sure they're still needed, because we should only have exemptions if they really, really are necessary. And I think we also have a lot of examples over time where we've seen exemptions taken away in favor of regular antitrust regimes, and that this has been successful. We know of other areas in transportation which are very complex, where DOJ is active and brings cases, and it has developed great expertise in the area. So from that perspective, both that this is something that's been around for a long time and likely needs to be re-examined, and from the perspective that we have, since that exemption was put in place, we have done experiments where we know that the antitrust agencies and courts can work with specialist agencies and can develop the expertise to handle antitrust in complex industries.
Melissa, feel free to respond and then continue on with your explanation of the Raut case.
Sure. I mean, I understand Kathleen's point about this is not necessarily the arguments I'm making about the Raut industry don't necessarily apply to carriers of other goods. But when you're talking about an industry in which, as I said, there's ubiquitous sharing of space, I think what the writers of the Shipping Act were worried about was that they were going to be hailed into court every other minute because they're constantly talking to one another. And, you know, with all the supply chain issues we've had, and especially right now with the UAW strike, it's only going to get worse. And people need cars. People need vehicles, trucks. I believe that there was a perception, and I think it still applies, that the ubiquity of the interaction between otherwise competitors was going to spark. I've done plaintiffs' cases, but plaintiffs' lawyers to bring cases, and really in a litigious society like ours, kind of bollocks up the stream of shipping, roll-on, roll-off vehicles. So I know it's a one-size-fits-all. I know that creates problems. But I still believe, and maybe because I litigated this for years, that there's a reason for the exemption, at least in the Raut context. Now, unfortunately for the plaintiffs, in this context, the district court, Judge Salas in the District of New Jersey, dismissed the case on a motion to dismiss based on the exemption, and the Second Circuit affirmed. And after Judge Salas dismissed it, then the plaintiffs' lawyers filed a class action before the FMC. And it was both indirect purchasers, IPPs, and direct purchasers, DPPs. And because it was filed late, they should have filed when they brought the initial case in federal court, because you could bring them on parallel tracks. The DPP's case was dismissed as untimely. They missed the statute. The IPPs were a different. They were dismissed because they didn't have standing. Now, as everybody knows, because of Illinois BRIC, IPPs can't bring in federal court antitrust suit. So,
Melissa, for some of our foreign listeners, can you maybe just say what DPP and IPP is shorthand for?
Sure. I'm sorry. The direct purchasers under the Sherman Act and a case called Illinois Brick, which is somewhat controversial as well. You could do a whole nother podcast about it. The only direct purchasers can bring a lawsuit under the Sherman Act for damages and treble damages. And the court in Illinois Brick, the Supreme Court, ruled that there would be too much double dipping if you allowed both indirect purchasers and direct purchasers to sue. Now, in other words, if you allow the direct purchaser to sue, and then they passed on their overcharge to the next stage, and it's usually wholesalers versus retailers, or there are always middlemen in these things. And the indirect purchasers, if they also recovered from the alleged violator, that would be double dipping. It would be a double penalty for the defendant. What has happened is in many states, and I don't have an exact number, but something like 40, they've passed state statutes, which are called Illinois Brick Repealer statutes, which basically say in the state of California, under the Cartwright Act, you may sue as an indirect purchaser as well as a direct purchaser. So what you often get in these mass actions, class action like the Raut case was, you get a complaint that will bring a case under the Sherman Act. It will also bring in California something under the Cartwright Act, in Florida, in all these different Illinois Brick Repealer statutes. They will also bring parallel complaints, allegations on behalf of indirect purchasers, which makes for quite a multi-tentacled complaint.
And so then what happened with those in this case? How did
in this case, the FMC said, we only have federal jurisdiction, and we're not going to. We're basically, the IPPs did not have standing to sue the indirect purchasers. We have no jurisdiction over what happens in California or what happens in Vermont or what happens in Pennsylvania. And so, then the FMC looked at it, and the plaintiffs had also made, or the defendants rather, also had made an argument that there was no vehicle for a class action in the FMC. The FMC did not reach that issue because it didn't have to. It had already dismissed both the IPPs and the DPPs on different grounds. Now, quite frankly, I was a defense attorney in that case. I thought that the argument that you can't bring a class action in the FMC was the weakest of our arguments. So I was glad they didn't have to get to it, because the FMC explicitly, its enabling statute allows for it to, when a statute is silent as to a particular procedural issue under the rules of civil procedure, they adopt explicitly the federal rules of civil procedure. So Rule 23, the class action rule, could be adopted by the FMC and applied. That would be frightening because just watching class actions around the country in different venues, it's applied very differently, let's say. And I'm not sure that an ALJ or the Federal Maritime Commission has any experience at handling class action, and it would be breaking new ground.
If I can have Kathleen come in at this point, because this issue of class certification, I know in the paper that David cited in your introduction, you talk about the enforcement gap. You raise class certification in particular, and I commend this paper to anyone who wants to understand your position more fully. I think it's available on the AI website. But Kathleen, can you talk a little bit more about this class certification issue under the FMC?
Yes. So as Melissa mentioned, the ability to bring a class action under the FMC or in front of the FMC is an unreached question. logically, it seems like it should be possible, given the federal rules of civil procedure. What I think primarily there's a private enforcement scheme under the Shipping Act for a reason. It was designed in order to allow for private attorneys general to bring cases, and to help with the overloaded resources of the FMC. That's part of, and to catch those, make sure that we don't have under deterrence. But what we've seen in the private sector is that that role can only be fulfilled fully with the class device. So that is what encourages pursuing people to pursue private actions. It makes it possible for smaller claims that would otherwise not, it wouldn't be worth it to the plaintiffs to bring their own private action. It allows for all of those benefits and ensures that the private right of action under the Shipping Act actually is able to create the deterrence that it was designed to create.
Melissa, if you want to respond to that or with some of the other arguments you see in favor of the exemption.
Yeah, I mean, I see Kathleen's point, but the private right of action does exist. We used to joke around during this case that this was a case of first impression and it was a case of last impression, because it happens so rarely that there are allegations of price fixing among ocean carriers. And the question of whether or not the FMC has the capacity to hear a class action is kind of irrelevant. And I joked around, it was scary because it was, you don't know what they will do, but they would probably rely on precedent across the country. And the precedent about how to apply Rule 23 is not hard. There's a 4-part test. There's, you can do it. I just don't know how in fact they would do it in practice. But Kathleen's argument is a little bit of a red herring because it exists. The private right of action exists. You can bring a Shipping Act claim and a class action before the FMC, at least until a court or the FMC says you can't. So while it may not be the optimal place to bring it, nevertheless, it does have specialized knowledge about admiralty law, about shipping law, about carriers, that I think it's important to bring. And, there's a big debate going on right now about the Chevron doctrine and whether or not we should rely on these specialized agencies so much, or whether courts should rely on the specialized agency and give high deference to them. And again, that's a whole nother podcast as well. But I actually believe that in this case, I had to basically learn the Shipping Act, and I had to learn a lot of admiralty law, and I had never done it before. And we relied on experts, and we relied on people like David who do a lot of it. I do think the outcome was correct in this case, and I think it was partially because the plaintiff's lawyers, knowing that this was a case of first impression, did not understand the Shipping Act well enough to understand how this would all play out. They ultimately decided not to appeal. They applied for en banc, and then they applied for cert to the Supreme Court, but then they basically, cert was not granted, as I recall, and rather than start up again, we agreed to settle it if we would not seek attorney's fees from the plaintiffs.
I would just respond to the one point about the effect of the availability of class actions. I think right now, what we're seeing is a logical explanation for why there should be class actions, and a logical legal framework for that, but uncertainty in practice. Maybe it's because the plaintiff's attorneys are less familiar with or some plaintiff's attorneys are less familiar with how the FMC works, or it may just be risk aversion because there is no concrete ruling that class actions are allowed. So that ambiguity, that uncertainty, I think, leads to less enforcement than there could be.
So here's another data point that I find interesting. So the Biden administration comes in with a great deal of expectation around renewed antitrust enforcement. And full disclosure, I worked on their transition, as I think others on this call may have as well. WooCon cantered the mug, using the whole toolkit for enforcement, all of that. In 2021, we see this whole of government approach embodied in the July executive order on promoting competition in the American economy, which creates a kind of a new mission statement for the US government to promote competition using all of its levers through all parts of the economy. And it goes agency by agency through every federal agency that has any competition enforcement authority, telling each of them what to do. It gets to the Federal Maritime Commission and says, you have to vigorously enforce your demurrage and detention practices in relating Shipping Act prohibitions. For those of you who don't know what demurrage and detention practices are, and I was today o'clock when I Googled this, D&D charges are charges for failure to pick up or return containers within allotted free time periods, which was a big deal in and of itself during the pandemic and the congestion at the ports. And this 2021 executive order was followed by a press release in February 2022 in which the White House called on Congress to, quote, address the current antitrust immunity for ocean shipping alliances. But in neither case did the White House explicitly call for the removal of the exemption. And maybe some of that is just the respecting the different branches of government. Am I reading into this? Am I reading too much into this? Or what does this group make of the fact that even the White House has not called for explicitly for the removal of this exemption?
I mean, it's self-serving, but I have to say, I believe that the White House and Congress, which did not pass a repeal, understood the arguments I've been making, that these things are necessary in certain areas of ocean carriers, excuse me, and saw the benefits of them and figured the benefits outweighed the detriments. Now, reasonable minds can differ about why Congress does anything or doesn't do anything, but that is the most favorable argument to my approach to this quandary.
So, from my perspective, I would say that I see the White House leaving open options. You can get rid of the exemption, or you can bring the FMC process more in line with the traditional antitrust enforcement. So, I think there are options for doing that. So, I see in that the possibility of reforming the FMC process to reduce the under-deterrence that's there right now, including by making it more like a typical antitrust provision, making it clear there's class action available, and making damages not so hard to prove and make them treble damages. Which has been found over time to be the right balance in regular antitrust enforcement.
Well, Kathleen, respectfully, I understand that there's a theoretical danger of under-deterrence, but in fact, it's not happening. You don't see cases being brought because, in fact, there isn't the same set of incentives to fix prices or violate the Antitrust Act when you have a finite space on which to put goods or vehicles or whatever. You have a finite amount of time at a port to unload and load. And I think that those realities of the business mitigate against the under-deterrence.
Well, I think it's hard to know unless it's tested. And, I think I've heard many times that industries don't have a problem with price fixing. And then when you actually get into the weeds, there's something going on. So I take your point that there are maybe reasons why there's less price fixing in ocean shipping, but I'm a skeptic in this area, and I think unless things are examined and there's discovery and there's investigation that you don't really know what's going on.
I hear you. I hear you. But as somebody who does antitrust law, as you do for a living, and ocean shipping, this was my only ocean carriers. This was my first and only experience. Most of what I see in class actions and private rights of action are low cost, low margin goods. And so it's much easier to, or there's much more of an incentive to fix the price of a plastic fork or plastic cutlery, which has, less than a cent margin on each unit, than it does on something as expensive and huge and time consuming as ocean carrying. And we can debate why people aren't bringing the cases. And I understand your point that there's less of an upside if you're a plaintiff's lawyer to bring a case in the ocean carrier venue. But there are also, as I said, practicalities that empirically are its own deterrents to fixing prices.
And this is, I think, the challenge with this. What Kathleen is talking about has been a trend, a general disfavoring of exemptions and lacunae for industries that fall outside of the antitrust laws. But arguing for the removal of protections for historically protected industry oftentimes involves theory or pointing to other industries because you're talking about like a but-for world. And that can be a challenge, I think, in making the argument. So normally at this point of our podcast, we provide a few takeaways for practitioners. And these are takeaways that the panel has generally agreed upon. But what's been so interesting about this is that there's a genuine disagreement here. And so I thought it would be better to allow kind of everyone to go around with their own separate takeaways from this episode, starting with you, Kathleen. What are your takeaways for practitioners?
So from my perspective, we really need to find ways for the experience of general antitrust enforcement to inform antitrust enforcement under the Shipping Act, including creating clarity about whether there is class certification and how it will be handled, transparency about the FMC's process, and more to make it clearer that how antitrust enforcement is evolving under the general regime is informing how antitrust enforcement is done under the Shipping Act.
I guess my takeaway is that when there's very little empirical evidence suggesting that there is a need for more deterrence, if it ain't broke, don't fix it. And I should point out that the antitrust laws, the criminal antitrust laws, are not exempt from the Shipping Act. Or by filing an agreement, you can still go to jail if you fix prices. In the Raut cases, there were fines levied and people were incarcerated. So I don't see, and I think that that's deterrent enough. I don't see the need for private enforcement at the level of some other industries. And so I think that the reason that Congress hasn't done anything is that there's no need to do anything.
I don't have a takeaway. I'm still tickled by this idea that the FMC is practicing some sort of air-gapped antitrust analysis. And just as a practitioner, I'm leery of forking the approach to competition enforcement within the U.S. David, what is your takeaway?
My takeaway is that we'll see what the FMC does. They're a very hardworking staff. As most administrative agencies, I'm sure they need more resources, but they work very hard. And also note that the Antitrust Division and the FMC released a press release that they're going to be collaborating on competition issues. And so we'll see what happens there.
Well, thank you, David, Melissa, and Kathleen, for walking us through this relatively obscure piece of law that affects practically everything within arm's reach. and for some genuine disagreement. We've never had people not come to an agreement on the takeaways. This has been great. To our listeners, be sure to subscribe on your podcast platform of choice, and we'll see you next time on Trust and Trade.